Welcome back for Module 6. And in Module 6, we are addressing the operational gap. Now, when it comes to the operational gap, the scenario is Halstead Co. Just a quick reminder of the somewhat scenario that we're using throughout this module. Halstead Co. is the legal firm, and we have Pemberton, which is their most important client. And they sent through a AI governance questionnaire. One of the questions on that questionnaire is, how does your firm monitor AI systems after deployment? Okay, so let's dig into the scenario a little bit more here. So you've got the IT lead for Halstead Co, Maya, and what she does is she goes to check the documentation relating to the AI tool Microsoft 365 Copilot in Outlook. And what she notices is that it has a status of under review and is flagged for further assessment due to the gap-free baseline. Now, Maya looked for the procedure governing the under review status, and she established that there was none. So there was no defined clock in terms of how long should a system stay under review before a decision is required. There was no answer in the policy or the procedure file. There was also no defined reviewer. So who exactly owns the reassessment? Is it the IT lead, COLP? Is it the board in terms of the AGL, or is it the managing partner? Now, there's no record of this, so there's no responsible, accountable, consulted, informed documentation that points to a member of staff that is responsible for this reassessment. And there was no defined outcome set. Legal options at the end of the review: return to active with conditions, or move to suspended pending GA implementation, decommission. There was no document that could define the outcome. So 90 days has passed since the status was assigned, status being under review. Nobody has raised this as a problem because the procedure that would have raised it doesn't exist. And this is what we're going to address today. So without a procedure that defines what each stage means, who decides the transition, and against what criteria, the register's status label is cosmetic and is not governance. So what happens when AI systems are adopted but never governed? You've got untracked vendor updates, OpenAI, Microsoft, and you've got Leap Legal. All updates their models at will, and sometimes without even any notice. A model update can change a tool's accuracy, its tendency to hallucinate, and how it handles edge cases. Without a lifecycle procedure that defines a material vendor change as a trigger event requiring review, these updates pass through the firm's AI estate undetected. The firm continues using AI systems whose behavior has changed since the original risk assessment was completed, all without realizing it. Okay, so what else can happen if AI is not governed? All right, you have an AI tool that's approved for litigation and chronology work quietly, gets used in immigration advice drafting, for example. Now, the fee earner treating the tool as a general purpose assistant has not flagged a scope change because the policy does not require it. The lifecycle procedure does not define scope expansion as a trigger event. The risk register now understates the actual problem. The original impact assessment is no longer relevant to the use case governance has drafted. What about AI model decommissioning? So when a firm stops using an AI tool, what happens to the data it processed over the period of time the firm was using it? What happens to all that data? Now, without a documented decommissioning procedure, data may not be deleted at all or retrieved from the vendor system. The system may remain in the register as active. When it is not, vendor agreements may auto-renew for another year, and the firm has no audit trail of the decision to retrieve the tool. A regulator asking, "When did you stop using X?" has no answer to point to. When it comes to the scenario and Halstead Co., their top client, Pemberton Capital, their fourth question in their AI governance questionnaire asks specifically, how does your firm monitor AI systems after deployment? Now, the honest answer today for Halstead Co. is we don't. Now, a response of we review AI use regularly is not an answer. Now, without a documented lifecycle procedure, the firm cannot produce a defined monitoring cadence, named trigger events, or audit trail for reviews. The 620,000 client relationship is exposed. So let's just quickly look at how ITIL perceives this. Now, in ITIL terms, Gap 5 represents a missing change enablement and service configuration management practice. All right, so that operational gap in terms of ITIL 4 is change enablement and service configuration management practice. Now, an AI system that was approved 18 months ago but has not been reassessed since then, in ITIL terms, is an unconfigured service asset with no defined change records. Now, lifecycle governance is the procedure that turns AI systems from things the firm use into services the firm manages. Without it, every other AI management system control operates on an outdated picture of the firm's actual AI estate. And that is how ITIL 4 looks at it. Okay, so let's look at what is required. So for ISO IEC 42001-2023, clause 8.2 is short in its written text, but wide in its implications. So per ISO IEC directives, part 2, the word shall is a requirement, should is a recommendation, may is a permission. Okay, so let's take a look at the AI system lifecycle. You have stage 1, which is pre-deployment. This is signed off by the board. And what is looked at is the impact assessment, the risk register, and obviously the board's approval. Now, once that is signed off, it's stage 2, which is active. There's active monitoring in place. There is the oversight, so the human in the loop. And there is the quarterly review that goes back to the board in terms of the state and quality of the AI estate within the firm. Then you have stage 3, under review. Now, at this stage, there is a 30-day window, a reassessment, and a decision has to be made. The decision is usually made by the AGL, which is the board. Stage 4 is suspended. Now, this is client work has been halted. There is no AI used for any client matters. The suspension can only be suspended for 90 days at a maximum, and the lead agent is notified of this suspension. Finally, you have stage 5, which is decommissioned. So you have the date of deletion, the register is closed, and the information of this decommission is retained for 3 years. That's the AI system lifecycle. Okay, so let's look at the clause 8.2 obligations, and we'll start with may. So the organization may integrate AI lifecycle procedures with its existing change management or service management procedures, provided that AI specific stages and trigger events remain clearly identifiable. This reduces document overhead but requires careful scope management. So let's look at recommendations. So a defined set of trigger events should be documented and automatically move a system from active to under review. 8 trigger events, which is covered in section 6, are the working standard expected by ISO 42001 auditors. Then you have each lifecycle stage should have defined entry criteria, stage obligations, and exit criteria. A stage that anyone can enter or exit at any time is not a stage. It is an absence of procedure. Then let's look at the requirements. So the organization shall plan the processes needed to meet AI system requirements. Planning includes identifying which AI systems need lifecycle treatment, who owns each system, and what resources are required. The organization shall implement the planned processes. A document on a shared drive that nobody reads is not an implementation. Implementation means that the process is operable, resourced, and that staff have been trained on it. Now, organizations shall control the processes during operation. This means active oversight. So active human in the loop, human review. Defined approval gates between stages, named decision makers, and recorded transitions. Then you have organizations shall monitor the processes. Monitoring is not optional. It is a procedural heartbeat that detects when an AI system has materially changed, whether that's a vendor update or an incident, and triggers are a reassessment. Next, you have the organization shall review the processes, a formal review cadence, usually quarterly and annually, and a ad hoc reviews on defined triggers event are both required. So we review when we have time does not satisfy this clause. So there has to be a set process in place where AI systems is being reviewed quarterly and annually, and also there's a process in place where there's an incident that triggers the event for someone to perform a reassessment. Then you have life cycle coverage shall explicitly include deployment, development, use, and decommissioning of AI systems. Most firms think only about deployment, but when it comes to clause 8.2, it requires governance across the entire AI system. So from procurement decision to retirement of an AI model, or an AI system rather. The organization shall determine the intended use of each AI system, including consideration of the social and societal context in which it is used. A tool approved for internal admin must be reassessed before being deployed into client-facing work. Then finally, you have the organization shall ensure the AI system is used within its intended scope and context. Use of this AI system outside the registered scope itself is a governance breach, even if the tool is the same tool. The deployment has changed. Now let's look how the SRA maps to this standard. Now the SRA does not use the word lifecycle. It doesn't need to, because there is 3 existing SRA instruments applied together that create the same requirement through the language of ongoing supervision. The timeline below maps each instrument to the procedural element of the procedure AI management system lifecycle documentation that satisfies it. So let's go down and take a look. So you've got the SRA AI guidance. So the SRA compliance tip for solicitors, and this is on the, I believe, the 9th of February 2026, talks about ongoing review. Now, ongoing review in the SRA's plain English version of the active stage monitoring obligation in clause 8.2, a firm that approved ChatGPT 4.0 in January 20 has not reviewed that approval since is not supervising its AI use. It is relying on a historical judgment that may no longer reflect the current tool or the current state of the firm's practice. Now, the procedural AI management system lifecycle document, its quarterly review and 8 trigger events are how Halstead Cole evidences the ongoing review to the SRA. It is that document that they are able to provide an SRA auditor to show that they are providing an ongoing review of their system, their AI use within the business. Then for SRA, they've got competence. So the SRA Code of Conduct for Solicitors 2019, the Rule 3.2 and 3.3. 3.2 requires solicitors to maintain a level of competence and legal knowledge needed to practice efficiently. Okay, so what that means is that you're not solely relying on ChatGPT or any other AI model. You're still using your knowledge and expertise, everything that you have developed to then now be an official solicitor. You've got to maintain that. That's not going away because you've got AI here. All right. And that is basically what Rule 3.2 is addressing. Solicitors to maintain their level of competence and legal knowledge. All right. Now, when it comes to Rule 3.3, It requires supervision of staff and adequate training. The SRA has confirmed both obligations extend to AI tools used in practice, including understanding what these AI tools' limitations are. The life cycle governance is how the firm evidence that the competence and supervision obligations are exercised over time, not only at the point of adopting these AI systems. Next, you've got the duty of the CLP. Now, the SRA Code of Conduct for Firms 2019, Rule 8.1, Section A, says that the CLP must take all responsible steps to ensure that the firm, its managers, its employees, and interested holders comply with their obligations under the SRA regulatory arrangements. So an AI system that has not been reviewed in 18 months cannot be defended as compliant under Rule 8.A. Now, the CLP has no evidence on which to base that defense without a procedural AI management system lifecycle documentation, which provides the documentation, the dated evidence trail that would satisfy this duty. And then finally, we've got the court precedent. Now, in the Allende litigation, which I have referred to in previous modules, quick summary. Basically, what happened, two lawyers used ChatGPT to generate some case law information, and they submitted it verbatim without checking it. And unfortunately, AI created fabricated and falsely attributing nonsensical opinions to real judges and embellished with further false citations and docket numbers held by actual cases irrelevant to the matter at hand. So basically, these two lawyers put together some documents that was created by AI on behalf of a client and submitted it to court. And naturally, it turned out that AI made up everything. Now, they ended up getting fined close to 90 million for that mistake. And the SRA actually addresses it here. So in the court, like I said, these lawyers relied on two AI generated case citations in a judicial review claim. Turns out that several of the citations, 18 to be exact, did not exist. The court drew explicit attention to the responsibility of the legal representatives to verify AI generated material before relying on it. The lifecycle governance, particularly the active stage monitoring obligation and the T2 incident trigger, is the procedural mechanism through which the firm evidences that verification, and that any verification failure triggers procedural escalation. So let's look at the first stage of the fix. What are the 5 mandatory stages of this procedural AI management system lifecycle document? So let's look at these 5 stages. So stage 1, you have pre-deployment, entry criteria, and approval gate. All right. So a system enters the pre-deployment when a fee earner, practice group head, or IT lead identifies a candidate AI tool. The entry criteria are concrete. So completion of the Part A Reg AI Management System documentation. It's the system description, the vendor, data categories, intended scope. Also the completion of Part B, which is the Reg AI Management System risk documentation. It captures the impact assessment with the risk tier classification and the assessment of a named AI system owner. Now, the approval gate is not a committee. It is a documented decision with a signature and a date. Now, the AGL, the AI governance lead, signs the approval. When it comes to the high-risk systems, the managing partner countersigns. No system may enter active status without passing this gate. The gate is the procedure's first defense against ungoverned deployment. So when an AI tool is identified, it is captured in two different sets of documents. One document is about the system itself in terms of the vendor and the category, etc. The next document is the risk assessment. So the impact and what risk tier it has been classified. Once that's done, it then goes to be approved both by the AGL and the managing partner if the actual tier classification is high risk. So criteria, entry criteria. So it needs part one, completion of the AI management system. Like I said, the vendor, the model, the data categories, what's the intended use. Part B, the assessment. So the impact assessment completed in the Reg AI management system risk documentation, where it's also assigned a tier, whether it's low, medium, or high. Then the AI system owner is named as being accountable for the system day to day. The disclosure determination is made. So does the system's use require client disclosure under G7, which is GAP 7? Then you also have the exit criteria. So all required before active status. So it needs the AI governance lead to sign it off on the pre-deployment improvement gate form. You also need the managing partner's counter signature for the high-risk systems only though. And you need the register entry updated so the status moves from pre-deployment to active with a date stamp. So that's stage one. Then you have stage two, which is the active monitoring obligations and review cadence. Now, an active system has 3 standard obligations that operate continuously. Together, they convert the risk register from a static document into a living governance instrument. And they are what the SOI means by ongoing review. So let's take a look at this. The standing obligations during active status. So you got the monthly model version check by the IT lead. So any model version change automatically triggers to under review because it needs to be assessed. Then you have the quarterly output quality review by the CLLP or the supervising partner. And this is recorded in the quarterly AI management system performance report. Pattern of errors or near misses trigger again under review so that it goes through another reassessment. Immediate incident reporting under the procedural AI management system human in the loop documentation. So any AI incident or near miss attributable to the system triggers under review without delay. So any incident, straight away the status changes from active to under review so that an assessment can be triggered. Now here's why active is not the end of governance. In clause 8.2 explicitly requires that the use of AI systems is governed and not just deployed. An active system is one of the most heavily governed stages in the life cycle. 3 continuous monitoring obligations plus 8 trigger events. Now, any firm that thinks that active means no further oversight is needed has clearly misunderstood the clause 8.2. Stage 3, under review. So you've got this 30-day window and defined outcomes. All right, so under review in the stage of the AI management system document has been stuck for 90 days. Now, the AI system that we're referring to is the Microsoft Copilot that's incorporated within Outlook. Now, that has been stuck in a status of under review for 90 days. Now, with the procedural AI management system lifecycle document in place, that status has structure. Now, the stage has a defined clock, a defined assessor, and a defined menu of outcomes, none of which exist in the firm's current arrangement. Now, let's look at each one. So, the clock. Under review has a 30-day clock from the day that the event was triggered. The clock starts on the day the system is moved from under review and is recorded in the Register AI Management System document. If the 30-day window expires without a documented decision, the system automatically transitions to suspended. Then you have the assessor. Now, as the AI governance lead, they lead the reassessment, drawing on the relevant risk register rows and the original impact assessment from Part B, which is the Reg AI Management System risk document. Now, the CLLP provides the input. For the high-risk systems, the managing partner is consulted before any decision is made. Now let's look at the outcome menu. 1 of 3 is required. Now, return to active. This is with updated risk register and, if required, new or strengthened controls. Recorded with a return to active date and an updated residual risk score. So now you have the transition to suspended. System removed from client work. Pending reassessment, of course. triggers the 90-day suspension clock, which is stage 4. We looked at that earlier on. Then you're looking at decommission. So the system will not return to active, triggers the decommissioning procedure, which is stage 5. Now on the under review decision recorded form. And this is the template that I've got provided for you that you could download from the link below. And that's the procedural AI management system lifecycle document, which is signed by the AI governance lead. And for high risk systems is also countersigned by the CLLP. Now, stage 4, suspended. A suspended system may not be used in any client matter. This is a hard rule, not a soft preference. And a breach of this rule is reportable to the CLLP under the firm's incident procedure. The suspension removes the tool from active deployment while a remedy is being worked on. Immediate actions on entering suspended status. So the CLLP notifies all fee owners. This has to be done within 24 hours and can be done either by email and by team meetings, so in person. The notification includes the system name, the trigger reason, and the date the suspension took effect. Now the board or equivalent leadership. They are notified within 5 working days. The notification is recorded as a board minute with the suspension reason, the affected matters, and the proposed remedy timeline. Register entry updated in the Reg AI Management System documentation. Now the status moves to suspended with the date stamp and the 90-day clock start date. Now when it comes to the 90-day rule, the 90-day suspended clock runs from the date of suspension, and if a remedy hasn't been found and a control has not been verified within the 90 days, the system is automatically decommissioned. The procedure does not permit indefinite suspension. It forces it to be decommissioned so that there's a resolution. Returning to active, a suspended system may return to active only when A, the remedy control is implemented and tested, and then B, the residual risk score in the Reg AI Management System risk documentation has been updated, and C, the AI governance lead signs the return to active form. Now without all 3, the system remains suspended and the 90-day clock continues to run. So that's stage 4. Then finally we have stage 5, which is decommissioned. Now decommissioning is a terminal state. The system is permanently retired, but retired does not mean forgotten. So decommissioning triggers 3 mandatory actions that create an audit trail and protect the firm from residual data exposure. So let's cover that. So the mandatory actions on entering decommission status. First, we got the data deletion or retrieval from vendor systems. This is documented with written confirmation from the vendor. The confirmation includes the data categories deleted, the deletion date, and the vendor's signature. For systems that has processed client personal data, this actually satisfies the firm's UK GDPR data deletion obligations. Then you have the vendor agreement review. Now this confirms termination, cancellation of any auto review clause, and document any data return or transition terms. Now many vendors agreements auto review on a rolling 12-month basis. Missing the cancellation window can result in another year of unnecessary data exposure. Then you have register entry close in the Register AI Management System document. Now this decommission date and the reason is recorded. So the reason of the decommission is recorded. The entry is retained, not deleted. So this is retained for 3 years as the audit trail for the system's entire governance history. The register entry is never deleted. It is the evidence that the system existed, was governed, and was properly retired. Now, why decommissioning is a governed stage, not an absence of one. So, firms that treat decommissioning as informal, we just stopped using it, for example, they leave themselves exposed to 3 fronts. Data protection under UK GDPR, contractual, where you have auto renewal vendor agreements, and audit, no evidence trail. The decommissioning checklist within the procedural AI management system lifecycle documentation ensures all three are addressed before the system is closed out. Now let's look at the 8 trigger events that move an AI system to the under review status. So trigger 1, the model version update. So vendor releases a new model version or updates the underlying model without a version change. The AI system has materially changed in behavior, even if the version number has not moved. Who needs to detect this? This is the AI lead. So it goes through the monthly release notes check. That comes from the vendor. What about the trigger time? The IT lead needs to trigger this within 5 working days. Trigger 2, incident or near miss. Now, any incident or near miss attributable to the system as defined in the policy AI management system document and the procedural AI management system human in the loop document includes fabricated citations, incorrect advice, data leakage, and undisclosure. So these fall under AI incidences or near misses. Now, who's meant to detect this is the fee earners using the actual tool itself, and they have an obligation to report any incident or near miss. Their trigger is immediate. As it happens, they report it. Trigger 3 is the scope expansion request. So the proposal to use the system in a new practice area, matter type, or data category not covered by the original impact assessment, used outside the registered scope is itself a governance breach. Now, who detects this? It's the requesting fee earner. So the fee earner that's actually requesting to use an AI tool for a different client matter. They're the one that detects this. Or in other cases, the practice group head. Now, when it comes to the deadline, their trigger is they need to put this proposal in before any expansion. All right. In other words, they cannot use the tool in a new client matter until they put this request in and it's been approved. Trigger 4 is the vendor terms change. So what is this? This is material changes to the vendor's data processing terms, privacy policy, or service agreement. Examples are change to sub-processor list, change to data retention period, changes to model training opt-out. Now, who's meant to capture this change in information? That's the IT lead with their quarterly contract review. And this trigger is meant to be triggered within 5 working days. Trigger 5 is the regulatory development. So with the new SRA guidance, legislation or court ruling materially affecting the firm's AI use in the relevant context. This also includes judicial decisions that was made in this case here that I mentioned earlier. Now, who's meant to be capturing these changes with guidance and legislation, etc.? That is meant to be the COLP with their regulatory monitoring. So they're meant to be keeping themselves up to date with any changes in standards or any court rulings. Now, any changes within the regulatory development, that COLP needs to trigger this within 10 working days. Trigger 6, you have the quarterly review findings. What this is, the quarterly output quality review identifies a pattern of errors, near misses, or control failures requiring reassessment. One-off issues are handled through supervision, patterns, triggers, under review status. And this is captured by, again, the COLP or the supervising partner, and is triggered within 5 working days. Trigger 7, you have the risk acceptance expiry. So what this is, a formal risk acceptance from the Reg AI Management System risk document, section 4, expires without the remedy control being verified. The clock on the risk acceptance is part of the register and not the calendar. It's the AI governance lead that will capture this, and the trigger is on the expiry date. Finally, you have the trigger 8, which is the supply chain change. So material change to the third-party API supply chain for a self-hosted or vendor aggregated system. Cross-references gap 9, which is supplier assessment, includes sub-processor changes and underlying model provider changes. This is picked up by the IT lead via sub-processor monitoring and is triggered within 5 working days. Now let's quickly touch upon the 3 triggers that most firms miss. The triggers that most firms commonly lack any mechanism to detect are trigger 1, so that's vendor model update, trigger 3, scope expansion, and trigger 2, incidences or near misses. Now, trigger 1 matters because vendors update happens frequently and silently. Trigger 3 matters because fee earners tend to use AI tool like a general purpose tool and use them in unapproved contexts without flagging it. And trigger 2 matters because firms handle AI errors as client service issues rather than a governance event. Now, without triggers 1, 2, and 3 being detected in a reliable way, the firm's active stage is ungoverned in practice, regardless of what the register says. So, let's look at the document control. So, how is the procedural AI management system lifecycle document filed, signed, and applied to existing systems? So, a lifecycle procedure without document control is just the memo. The ISO 42001 clause 7.5 requires that all AI management documentation carry a defined set of metadata, which is the ID, version, owner, classification, issue date, review cycle, retention, and related documents. The block below shows what Halstead Co. in the scenarios, what their control block look like when it comes to the procedural AI management system lifecycle documentation. All right. Now, this is also the same as the template that I'm providing you. So you've got the document ID, the version, the status, the ISO clause, which is clause 8.2, who's the owner, who's it approved by, the next review date, and the documents that it's linked to. And this is what we got right here. So you've got the document ID, the title, next review, related documents, obviously the version control, status, owner, date of issue, and what is its retention period, which is 7 years. Okay. Now, what happens after the procedural AI management system lifecycle document is issued? On day 0, the AI governance lead issues the procedure. So that document becomes active. So status changes from draft to active. The date of the issue is recorded. The under review status 30-day clock for that AI management system, in this case, this is the Microsoft Copilot, it begins on this date. Then, within 14 days of the document being issued, the AI management system move from their current informal active state to a documented active state. The pre-deployment gate form is completed retrospectively with a note that the system was already in use at the AI management system implementation date. The risk register scores are attached and the AI governance lead confirms continued active status subject to the remedy timeline in the risk acceptance record. AI management system starts its 30-day under review clock on the issue date. Okay, on day 30, the AI governance lead completes the under review decision record for that AI management system. The decision is one of 3. Return to active with conditions, transition to suspended pending full V8 implementation, or decommission. The decision is signed by the AI governance lead and countersigned by the COLP. Now, within 30 and 60 days, Pemberton Capital need their questionnaire answered. Okay, Halstead Co. responds to Pemberton Co.'s 4th questionnaire question with a copy of the procedural AI management system lifecycle documentation attached, the current register status of each system, and the date of the most recent under reviewed decision. The answer is no longer we review AI use regularly. It is, here is our documented lifecycle procedure. Here are the 8 trigger events. Here are our monitoring cadence. Then day 6, 120 days, there is the continuous monitoring. So monthly model check, model version checks by the AI lead begins. The first quarterly output quality review is scheduled. The 8 trigger events are referenced in the IE's monthly checklist and the COLP's quarterly review template. Now, from this point forward, the active stage is governed continuously rather than left to drift. So let's just quickly recap on what this gap covers. What does this document close? So the procedural AI management system lifecycle document is the operational engine. It does not by itself satisfy the firm's data governance requirement, which is gap 6, which we are covering in module 7, the client disclosure obligation, or the human oversight procedure. Each of those documents is a separate procedure that plugs into the life cycle at specific stages. Data governance defines what data may enter pre-deployment, and disclosure determines whether the system triggers the disclosure obligations at active. Human oversight defines the output review mechanism that operates throughout active. So this is what we'll cover in module 7, and module 7 closes the gap 6 through to the gap 9 sequence. Again, I provided some quick quiz questions that you can test yourself on, as well as a checklist at the end as you're going through this module and understanding the system, understanding the standard, understanding the 5 stages, and getting yourself ready for module 7. So just a quick preview of what module 7 is. Module 7 closes the remaining operational gaps. So with the scenario, Halstead Co. will produce its data governance register for gap 6, its client disclosure procedure for gap 7, its human oversight procedure for gap 8, and its supplier assessment regime for gap 9. With these in place, the lifecycle procedure from this module governing how each is applied and updated, the AI management system becomes a complete operational governance architecture rather than a collection of standalone documents. Check out the link below for this HTML. And also, I provide you with a template for each gap. So this is the AI System Lifecycle Procedure document. So we show that the lifecycle stage overview, what happens during the pre-deployment assessment approval. This is when the AI system has the status of pre-deployment and its sign-off. You've got the active deployment and monitoring. So this is when the AI system status is active. What are the monitoring obligations? What is the entry and exit criteria? Then you've got the under review status. So what is the entry criteria for an AI system to be put under review? What is the obligations within the status, and what is the actual outcomes? Then you have suspended from client work. Again, what entry brings an AI system into this status? What needs to be done? And what is the exit outcomes? And then, of course, you've got the decommissioning of the actual data entry, the mandatory steps that needs to be done, and then the post-decommission steps. Section 7, I've provided the breakdown of the 8 trigger events. So you've got the trigger events. I provided a description, the owner of the trigger, their timescale, and the actual AI management system that is affected by the trigger. And then you've got the retroactive baseline entry and the different steps when it comes to implementing a new AI system within the firm. So again, you have your version history and your communication logs. So this is your template that you can just download, tweak and make changes as you wish. You could get this in the link below, as well as the HTML of this module that we've just gone through. This is module 6, and I'll see you in the next video.